I gotta apologize. I've been a very rude person, not even regarding station or status, just a matter of communication. I felt insulted. And in the course of feeling insulted, I visited insult on insult. I had very little respect for a recent Supreme Court ruling regarding payment on medical insurance and understanding that the government was responsible for paying outstanding bills associated with medical insurance. To be honest with you, I couldn't even read the whole opinion. I just couldn't. I was though so disappointed. There were all kinds of things about the decision and the context for it, including the fact that I was trying to undergo some litigious efforts on the district level and felt that they were being disabused by people who were abusing the power of the bench. But primarily, the reason why is because in the beginning of 2018, I experienced what I understood to be election interference concerning early voting in Houston, Texas. And I contacted the Board of County Commissioners. There was a process that was available via the laws of Texas. And I contacted them. I contacted every member of the commissioner as well as the commissioner's court. And I requested that they begin a formal process within a specific period of time in order to apprise people of information concerning the details of this particular provision, as well as how we could engage ourselves in exercising our rights or options to it. There was, at that time, more than a year of what I understood to be unconstitutional process ongoing in Texas concerning bond fraud. Specifically, I believe, the governor of Texas overstepped his bounds when he recriminated, or rather reproached, certain other elected officials in performance of their ministerial duties in terms of attending to the local matters at hand under their jurisdiction, and decided he was going to threaten to withhold funding from their jurisdictions if they did not cede to his demand that they refuse to engage in their duties. Now, sheriffs, by law, have a certain way that they are entitled to execute decisions regarding performance of their duties. But in order to qualify for sheriff, you must also qualify for a particular kind of surety that they must then sign over to the governor. And while there was already constitutional consideration about the governor's role in this manner by virtue of the fact that the challenge to them, if it were to come, should have come from the legislature. That's one part. But the second part had to do with the fact that as the signatory, the holder of the bonds on the sheriff, he was completely beyond his mandate and his authority to lean on their bonds or to threaten to impact the bonding or the sureties on those sheriffs in order to see to an unconstitutional consideration of performance of their duties. Now, nobody in Texas brought this up, but we have a very significant problem in this country and have for a long time in terms of being honest with what exactly a bond is, how to go about executing a bond, how to go about honoring a bond, what constitutes a legal bond, and what does it mean to engage consensually in a process of bonding. Texas, I believe, is especially egregious in this manner, and it is magnified when one has to take into consideration the different kinds of sureties and insurance, the different kinds of law enforcement, including elected law enforcement in the state of Texas, are committed to. This is part of what I understand is the wrangling that goes on in what I have alleged is pension fraud, or rather racketeering. That an intentional disabuse of appropriate policy regarding bonding and obligations connected to bonding, as well as other kinds of matters related to the backing that members of law enforcement have, as well as their constituents, is intentionally manipulated at a high level. And these recent laws allegedly passed in the last September session, including ones that went into effect on January 1st of this year, regarding confidentiality of information that was previously mandated to be made publicly accessible, is part of a criminal conspiracy to obscure and obstruct how members of the legislature and the governor, aided and abetted by the Texas Supreme Court, have engaged in completely illegal processes under numerous codes in Texas, including the Texas Government Code and the Texas Comptroller's Code. So when we get to the issue of last year, the Supreme Court of the United States taken under consideration a requirement for, on a federal level, regarding compelling people to pay, or the government to pay, for outstanding medical insurance claims. Two matters come immediately into consideration. A, Texas, the state of Texas, is responsible for the incorporation of numerous business entities and the headquarters of numerous business entities that are instrumental in the insurance sector, including the medical insurance sector, but also other kinds of insurance that impact the kind of access and the other kinds of need and demand for medical insurance in other sectors. And I believe that they have been aided and abetted by this criminality that has been allowed to proliferate in the state of Texas. And B, the Texas Supreme Court, in the end of 2018, submitted to the Supreme Court of the United States request for consideration regarding the constitutionality of the Affordable Care Act after it had obstructed numerous kinds of process in the state of Texas, including process through the Texas Insurance Commission, and including process through the Texas Health and Human Services Commission, to seek redresses for egregious offenses connected to implementation of various activities associated with the Affordable Care Act marketplace, specific to Texas's understanding of its role. So those are two major challenges to a consideration of why other kinds of considerations regarding whatever obligations are associated with outstanding medical billing claims or medical insurance claims after this time frame of the Affordable Care Act has been allowed to unroll were insulting. Anyway, as I was saying, in the beginning of 2018, as far as I remember, prior to the governor of Texas making an on-site visit to Houston, Texas, I contacted every member of the county commissioner's court, as well as the head of the county commissioner's court, and I had asked them to provide information to the people of Harris County and Houston specifically about how we could exercise Section 88.008 regarding self-insurance instead of bond. Now, my understanding is that this has been effective since May 18th of 2013. So there is precedent, and there is a reason why it is still on the books up to this time. But I never heard back. I got a acknowledgement of receipt from one member of the Commissioner's Court. I requested that they consider it and respond within a timeline that was actually part of what would be their legal response by law. They never responded. And they continue to engage in acts of election interference in Harris County and Houston specifically while I was there, that I believe I was witness to later when I was in Austin, and then even still later when I was in Dallas, and then even still later when I was in Fort Worth, and then again back in Dallas throughout the entirety of the year of 2018. Section 88.08, self-insurance instead of bond. A, notwithstanding any other law requiring a county officer or employee to execute a bond as a condition of office or employment, a county officer or employee is not required to execute the bond and may perform the duties of office or employment if 1. The Commissioner's Court by order authorizes the county to self-insure against losses that would have been covered by the bond, and 2. The county judge approves the order adopted under subdivision 1 if the county judge was required to approve the bond under other law. B. An order adopted by the Commissioner's Court under subsection A shall be kept and recorded by the county clerk. Now, the reason I wanted explication of this, because I didn't understand the specifics of it, especially understanding that there are multiple jurisdictions that often overlap. But one of the things I understood is that by keeping appropriate personnel records, including records of compliance, there can actually be an accrual of a value-added component regarding people that work within the official political subdivision. It's one of the reasons why when you become a sheriff, it's your personal credit that must qualify for the bond, which is distinct from the, which has a distinct methodology from the constable. and also has a very distinct methodology from the police department as well as the state troopers or other kinds of law enforcement. And so, in consideration of that, the role of the sheriff in the county and the capacity for that county to be able to self-insure instead of engaging in a variety of other bond processes, including participation in municipal bonds or municipal bond issues, which also have as a component of them reserves that are constituted by group insurance policy by employees of the political subdivisions of concern, is very significant. If the county has the capacity to self-insure because it has the capacity to cover obligations, then this can create a different kind of relationship, not only around municipal financing or around financing on a particular jurisdictional level, but it can also provide an alternative to some sort of corporatized process whereby people are arbitrarily obligated to insurance methodologies or modalities that may not serve their needs. So I never heard back from this. But I think this is particularly relevant right now because my understanding is there's been a public notice about how members of the Department of Justice and employees of the Department of Justice have erased their cell phones. Their cell phone records are gone. And one of the things we've been dealing with is this relationship between emails and cell phone records of employees while they are in performance of their official duties. Now, I've contended for a considerable amount of time that there needed to be a greater focus on law enforcement's personal use of cell phone as well as private security at public facilities and their personal use of cell phone, that it's unacceptable. And I believe that it's actually part of some sort of alleged national security paradigm that's actually proven to be completely contrary in serving the interests of national security. But more than that, the timelines and the efficiency of employees that are in performance of their duties within a public entity or within an official capacity can actually provide a sort of referencing of the kind of performance that they have on the job, as well as the means by which to evaluate them for a value-added aspect of their job duties that can actually contribute to self-insurance. Yet the political subdivision or the agency itself can self-insure because it has competent staff. It has competent staff that do their job and meet their benchmarks, and it's demonstrably proven. If they need coverage, they already got it covered because they did their job. This isn't about workers' rights. These people had a duty in order to protect the people they serve. And so when it comes to considerations of that, trying to approach this from a traditional employment or jobs perspective, it's not enough. This is not about people that create jobs getting credit. If we were talking about workers' rights, then we needed to be talking about things that had already acknowledged that bloated bureaucracies that end up charging some sort of fee or penalty to the people that their constituents are supposed to serve is not acceptable, just as it wasn't acceptable for a governor to overstep his jurisdiction and engage in securities fraud when he leaned on the sheriff's bonds.